Great. Well, hello, everybody, and welcome to a new session of Law at the Library, which is a partnership between the Evanston Public Library, the Chicago Public Library, and the Chicago Bar Association. My name is Lorena Neal. My pronouns are she, her, and I'm the legal literacy librarian at the Evanston Public Library. We're delighted to have everyone here tonight to discuss this evening's topic, real estate transactions, tips on buying and selling a home, with our presenter tonight, Justin Strain of Front Door Legal. I'm going to tell you a little bit about the format for this evening, and then we'll get everything started. I'll introduce our speaker, who will then give the presentation, followed by a question and answer period. So if you have any questions for our speaker, please type them into the Q&A window, which you'll find near the bottom of your screen, or you can also use the chat feature to ask your questions there. I'll collect all the questions as they come up and give our presenter the opportunity to answer them at the end of the program. So feel free to add your questions whenever you think of them. And if you have any technical issues or other questions, feel free to direct those to me in the chat as well. Our next Law at the Library session will be a discussion on women's issues in the law on Tuesday, March 28th. You can see a list of upcoming topics and registration links on both Evanston Public Libraries and Chicago Public Libraries websites, and I'll post a link to those in the chat once we get underway here. You can also see videos of previous topics on the Evanston Public Library YouTube page, and I'll post a link to our Law at the Library YouTube playlist in the chat also if you're interested. As I said before, our speaker tonight is Justin Strain, the founder of Front Door Legal, a law firm focused on real estate issues. So welcome, Justin. Thank you for being here, and tell us a little more about yourself and your practice.
Sure. Thank you, Lorena. I appreciate everyone having me. And thank you to Evanston Public Library and Chicago Public Library for putting this together. This is great for all of you to have this benefit. So my name is Justin Strain. I've been practicing law in the Chicago area for about 13 years. And that's primarily been in residential and commercial real estate transactions. We also do estate planning here at Front Door Legal. So basically, we help clients navigate the complexities of residential and commercial real estate transactions. We're trying to take the stress out of that process as much as we can for you. It's real estate. There are surprises every step of the way. That's just part of the game. It's part of what keeps it fun as an attorney. But we always want to do the best to educate our clients and make sure that you understand what's going on at every step of the process. And then on the flip side of the transaction, once you've closed and you've purchased your home, we want to talk with you and make sure that you're taking time and taking steps to protect everything that you've worked so hard to put in place. So that's where the estate planning piece comes in. I'm going to jump into screen share here and get started. I have a number of topics to cover tonight, and I also want to make sure we have plenty of time for questions because this is a very complex area. So just bear with me for one moment. All right. Is the screen share working? Everything's good?
Thumbs up.
Okay, perfect. All right. So as Lorena was saying, this is just a quick reminder of next month's topic, women's issues, a legal discussion. And also in April, how to start a business. And otherwise, I'm going to jump into my presentation. So as I was saying, Front Door Legal, we're focusing on residential real estate transactions, and that includes existing homes, condominiums, new construction. We also work on commercial real estate. So our clients tend to be investors and smaller business owners. But we do work on new developments. We put in place new condominium associations on the developer side. We work with clients on mixed use projects, multi-unit, and also commercial leasing. We do not take care of residential landlord tenant matters here at the firm. So that's just one nuance of our practice. So the way I wanted to talk about home tips for both buying and selling a home, and I want to make clear, I incorporate condominiums into this discussion as well, not just single family. I want to cover the basics of what the main contingencies are, in the real estate transaction process here in the Chicago and Evanston area. And then try to give each, a few actionable tips for both the buyers and the sellers out there that are hopefully going to make the process a bit smoother for you. So at the outset, if you're buying or selling, everything really kicks off when there's an accepted contract. So all that means is a buyer has submitted an offer, and then the seller has signed off on the offer. We have the offer, we have acceptance, we have a legally binding contract. And at that point, most of the contracts in this area are based off of one of two contract forms. I'm not going to go into the specifics of the differences between those forms. I thought that might be a bit too much information to cover on the session tonight. If you have questions about your transactions, you're always welcome to contact me. I'd be happy to see if I can be of service to you. Both of the main contract forms in use are going to have an attorney review and an inspection contingency provision. So first, attorney review, that's my chance as the attorney to look at the contract, look at the listing, speak with you, speak with your real estate agent, and learn more about the specifics of your transaction. And then based on that and based on my experience, we write an attorney review letter to the seller's attorney, or if I'm on the seller's side, sometimes to the buyer's attorney. And we're going to discuss and request modifications to the contract. And I know we have questions rolling in. I'm going to let those just kind of sit. We'll cover those at the end. So please feel free to submit, but we'll discuss them at the end. For attorney review, we typically have a rolling 5 business day period from the date of acceptance on the contract. So if the seller signs today, on February 28th, we have an accepted contract. The attorney review request would be due next Tuesday. That's the 5 business day period. Also within the attorney review period, if we find out that the transaction's not going to work for one side or the other, this is basically the period where your attorney can send notice to the other side. You can get out of the transaction. There's no penalty involved. So that means on the buyer side, you will be getting your earnest money back so long as notice is provided timely. Now, running at the same time as attorney review, there's the inspection contingency. So that's exactly what it sounds like. That's your opportunity to go through the home, go through the condominium with a professional licensed inspector and actually get a report about the physical findings in that unit. Okay. The number of days to have the property inspected, I have typically 7 to 10 days here. Those are calendar days. I will warn you, the contracts, the way they're set up, normally it's 5 business days and it runs at the same time as attorney review. Whether you'll be able to get an inspector in within that time, that usually depends on how busy the inspectors are. So for example, in January, things were quite slow. We were seeing inspectors visit a property within a day or two of getting the contract together, getting it accepted. Right now, we're seeing inspectors take a little bit longer to get out to the property. If you need additional time, your attorney will be sending an extension letter to the other side, making sure that you preserve this contingency, that you don't waive it. After you get the inspection report back, if you're working with me, I review the inspection report with you as the client. I'm not a contractor, I'm not an estimator, but I do have a wide breadth of experience reviewing these and just can provide some perspective from deal to deal. On the buyer's side, if there's defects that come up, we're going to be typically requesting a credit. So that's cash provided to you on the closing statement that lowers your cash to close instead of a repair. So we call that a credit in lieu of repair. You might be requesting that the seller actually fix items. And usually there's going to be some back and forth between the attorney on the buyer side and the attorney on the seller side to reach resolution for all of the items brought up in attorney review, all of the items brought up in inspection. Similar to attorney review, if you raise issues in inspection and the seller's unwilling to fix them, or perhaps you're not happy with the seller's responses, you're going to have the opportunity to exit the contract and receive your earnest money back. Similar to attorney review, and I did not put this on a slide, if you're dealing with a condominium, in this area. There's also going to be a condominium association or homeowner association review period to review the governing documents. It's a little bit more of a complex contingency. So it typically is going to be, once the association documents roll in, you and your attorney will have 5 business days from the receipt of each document to review them, try to tease out if there are any objectionable issues. So for example, maybe there's a large capital expenditure project in the near future that's going to require a special assessment, and you don't want to be responsible for paying that. That's your opportunity to raise objections and try to work it out with the other side. So there is a contingency in these contracts for HOAs, for condominium associations. It's outside of attorney review, and it is on its separate rolling 5 business day period for each document. So, I mean, high level, the importance of attorney review and inspection contingencies, this is really your chance at the outset to make sure that this transaction's for you. On attorney review, some of the main concerns we might have, especially with the rise in property taxes, making sure that your property tax treatment at closing is handled properly. That's a very complex topic in and of itself, but with the rise in assessed values, especially for instance, down here in the city last year, we were seeing clients go under contract for homes, and in the upcoming year, the assessed values were jumping 30, 40, 50%. So if that had not been handled properly in attorney review, our clients could potentially have been stuck paying a large amount of the seller's tax bill. And that didn't happen. We check all of this on every contract, but that's, in attorney review, having that chance to go through the public records and modify that contract to your specific need, to your specific closing. That's the key point of attorney review. And inspection, it should be obvious, but every once in a while, I get a client that would rather save $500, $550 than have an inspection. You never know what you don't know about a property. Even if it's a condo, even if it's 1 bedroom and you think that nothing could possibly be wrong, get the inspection. You do not want to make this large investment and have a lack of knowledge about the home, the condo. Just make sure you're going in with your eyes wide open as much as possible. All right, so heading into closing, I'm going to cover the buyer's side first, and this is just how my office approaches it. I'm sure with other attorneys, they have their own style, but this seems to be pretty common from office to office. So on the closing day, normally that's when you're going to do your final walkthrough. Okay, now final walkthrough, that may also happen 24 to 48 hours prior to closing. That just depends on the schedule that you and your agent work out with the other side. My office doesn't get involved with scheduling final walkthrough. We just make sure that it's happened and that you're satisfied with the results. So we always encourage final walkthrough be completed as near to the actual closing time as possible. That gap period, we just want to make sure it's minimized in case there are any unexpected changes. After the final walkthrough, you're going to go to the title company, and that's going to be in person. Most of the deals for a residential purchase involve some form of financing. While lenders are starting to move towards a bit more of an online system, we are not quite there yet. So you are going to go to the title company in person, okay? And as far as your attorney goes, when COVID hit, I went full remote and I did most of my closings remote for about 1.5 years, 2 years. And the way that worked was we would do a Zoom presentation such as this. The title company would send your loan documents, the seller transfer documents over to our firm. We would review with you on a screen share. You would sign real time. I am back to attending closings in person, but that will vary from attorney to attorney right now. What does the attorney do? So we're going to go through this loan document pack. That may be 30 pages, that may be 110 pages. It just depends on the loan and how it's set up. So we're going to explain the loan documents to you. Note that I said explain. We don't have any control over the contents of those documents. Those are usually going to be federally regulated document packs. And candidly, if you want the loan, you agree to the lender's terms. So we're explaining to you that loan document package. We want to make sure you understand what you sign but we're not negotiating those for you. Then we're going to review the seller transfer documents. We will review title again, make sure that you have clean title, that everything's drafted appropriately. At that point, if there's any changes to be made, we make sure those take place. If there are no changes to be made, we let the title company know on your side as buyer's representative that we are okay with funding the deal. And then you're waiting on the lender to also review everything that you just signed and respond to the title company to say, okay, title company, you have permission to spend the money and fund the deal. And that means that you're closed. Typical time for closing on the buyer's side, no matter how fast I can review the documents with you as a buyer, usually by the time we wait on the lender and all of the pieces to come together, I would say about an hour, 15 minutes to hour 20 tends to be our average. On the seller side, usually you have it a bit easier. So seller side, most of the work is completed prior to the actual closing day. So once we know that attorney review and inspection is closed up, that if it's a condo, there aren't any issues coming out of the condominium document review, we get in touch with our seller clients and we draft all of the closing documentation, send it to the client. And with our firm, you have an option. You can come visit us in person. My staff and I, we're all notaries, or you can find your own notary and get the original documents back to us before closing. One of those documents is a limited power of attorney. It says that I have permission on the closing day to sign off on some of the less substantive documents. That way you don't have to attend closing. You're not having to be on call all day for immediate document signatures. So that's how we approach it. Closing day, I run point. I keep you updated. I obtain your approval for signing off on the final figures, and then we complete the closing. All right. 3 tips for home buyers, and these are far from the only 3 tips, but 3 things that I wish my clients would come into the process all the time doing. Number 1, if you're obtaining financing, get a pre-approval letter from your lender, from your loan originator before you begin house hunting. If you're working with a good agent, they should almost just mandate that you do this. Pre-approval is different than pre-qualification. So pre-approval means that your lender has actually obtained your consumer data and verified it. So that's a stronger letter to go out there home hunting with, to present to sellers to make an offer with, than a pre-qualification. Pre-qualification, you've presented data to the lender, and it's basically the lender saying, okay, if all of this checks out when we do our due diligence, and it's true, then we should be able to issue the loan, but we have not actually verified anything. That's going to put you in a weaker position if there are multiple offers placed on a property. So always advise, if you're obtaining financing, obtain the pre-approval letter. I already covered the home inspection point of this. Get the home inspection. Do not pass on that opportunity. Do not try to save $550 and think that you know better than the home inspector. Just get the inspection. Yeah, just do it. And then we also talked about the property tax credit. If you're working with our office and you're a buyer, we go through the property tax credit proration process with you as part of our standard process. If you're working with another attorney, make sure that you ask them to explain that tax credit and why the attorney believes it's adequate. We're not trying to put them on the spot, but you want to understand how that calculation is being made and just make sure that you aren't coming out in a position where you have to take on some of the seller's tax liability. All right, on this home seller side, one thing that I advise clients to do, and a lot of the better agents out there will advise this as well, consider obtaining a pre-sale inspection report. And what that means is you actually, before you go to the market, you hire the home inspector on your side as the seller and have the property inspected. And the reason you're doing that is to get ahead of the game. So this gives you two opportunities. Number 1, you at least, if you make no repairs, have an idea what the buyer might be bringing up in their inspection contingency letter. So that's part 1. Number 2, If there are any physical condition items that you might want to take care of before you go to market, this is your chance to fix them. And then when the buyer goes through the property, they're going to see that they're not necessarily going to see that that issue exists because it's been resolved. So that can put you in a better position as a seller. Number two, and this one kind of goes for buyers as well. Work with an agent with an established track record. I see this all the time. The agent that comes in with the lowest commission, or the family friend that you're trying to help out, but they might not have the most experience, especially right now with this being a competitive market, low inventory. Now is not the time to go with an agent that doesn't know what they're doing, or they're just getting started. And I hate saying that, but you're going to be in a competitive market. There's no way around it. On the buyer side, you want to put yourself in the best position to win on the offer. On the seller side, you want that agent guidance in place so that you can help navigate all of this. And that comes down to understanding all of the components of the offer submitted. So on the seller side, just because you have the highest priced offer, that does not always mean it's the best. Keep in mind, these contracts, there's other components. So, for instance, if you have a higher offer, but it has a full inspection contingency, and you have a slightly lesser offer, but it has an as-is contingency, which one's better? Well, the as-is contingency allows the buyer to conduct an inspection, but at the end of the inspection period, their option is supposed to be just take the property as is or walk away from the deal. There's pros and cons to both of that. Again, an experienced agent is going to be helpful to you walking through that process. So those are the high level points that I wanted to cover. Again, as Lorena said, you will have access to the slide deck. Feel free to contact me. I'm happy to touch base with any of you on questions you have. If you would like to explore whether there's an opportunity for us to work together, I am offering 10% off of our standard representation rates. Just reference CBA when you get in touch with me. If we end up working together, we'll take care of that. With that, I think I'd like to open it up to questions. So that's
great. So we have a couple of general questions. I think we'll start out with the more general ones first. The first one is, can you point out a few main things to watch out for when you're selling a home by owner?
Yeah, that's almost a loaded question, the whole thing. So first, kind of like an anecdote. When I was growing up, we lived in Southeast Michigan, and my father had several rental properties, and he was always convinced when he went to sell those properties that he knew better than the real estate agents in the city, and he insisted on doing for sale by owner, FSBO. And growing up, I just have really not painful, but kind of funny, awkward memories of him navigating that process and how bent out of shape he would get over every little thing. I get it. The real estate agents, total between the agents is usually going to be a 5 to 6% of the purchase price split. It's a lot of money. I get it. The agents usually are also going to say, you worry about your the purchase price, let me worry about covering the difference in the 5%. If you're going to go for sale by owner, just keep in mind, you're still going to likely have to pay somebody to account for the extra expertise. So the way we handle it, we do not charge that, on the seller side. If you go for sale by owner, it's not the $695 flat fee. We're up around $1,200 for that representation, because everything the agent does, including trying to coordinate inspections, that now falls on our back. So there's going to be added expense. Depending on the attorney you work with, I have a process for working with my clients through the for sale by owner process. I'm experienced with it, but if you have an attorney that is a bit more hands-off and you also are less experienced, it's going to become a situation of you don't know what you don't know. And then last, one thing I could see this becoming an issue. For the inspection, when the inspection requests come into you, keep in mind, the attorney typically never sees the property in person. We're like the armchair quarterback on the side a lot of the time. If you have an agent out there, they're out there on the property, they're doing the showings, they see the actual physical condition. That can be beneficial to you in negotiating the inspection contingency resolution. Likewise, they're kind of the boots on the ground. Like the agent will actually deal with the other agent. For the buyer, sometimes they will have be able to meet the buyer directly. As attorneys, we are ethically forbidden from contacting the buyer directly. We just deal with the other attorney. And sometimes the attorneys are not very forthright on what they actually share with us. So those are all kind of things to look out for. And then last, if you are the type that takes things personally and cannot stay objective, please hire an agent. Keep in mind, especially if you've owned a home a long time, people are going to ask you for things coming out of inspection almost certainly. And if you don't have that ability to kind of stay objective and realize at the heart of this that it's a business deal, having that extra buffer, having your attorney, having your real estate agent in there kind of take some of that emotion out of it and just present you with the non-emotional objective situation and your options, that can be a huge help in managing your stress.
Mm-hmm. What about the flip side? What if you're interested in purchasing a house that's for sale by owner? Is there anything you should consider in that circumstance?
Yeah, I mean, consider that similarly, you're going to have somebody closer to the transaction and they might think that the property is in great condition. You get your inspection, it's not. Now you're having to convince that individual, potentially just via their attorney, that certain items need to be taken care of. If you're trying to negotiate tax prorations with the seller and maybe their attorney's doing a good job on this, maybe not. But again, just kind of that lack of knowledge and lack of that additional expert in their corner arm. In my experience, the for sale by owner transactions tend to go one of two ways. The first way is you have two very closely related parties and things tend to work themselves out. I would say more often than not, though, it ends up being a bit of a more emotional experience. It's bumpier and more stress is involved just because you're lacking that key component on the kind of that expert position in the team.
Great, thanks. Another question, how do you find a great inspector?
So all of your real estate agents generally are going to have their list of their preferred vendors. This goes back to why I say try to pick a real estate agent team that has an established track record. If you're working with someone that's been at it a while and they are very good at what they do, typically the inspector they have also is going to be very good at what they do. If you have questions about that, I honestly hit Google. Google is such a great place to do a quick background check. I mean, if you have an inspector that was recommended to you and they have 0 reviews at this point, I'd say take a look around. Just one team in the area that has tons of reviews out of several, like Home Inspection Geeks, there's a shout out. Like they have tons of 5-star reviews. Go to Google, do some background checks, see what other people that are in the same situation are saying if you have questions.
Great. Someone else wants to know, do I, as a buyer or a seller, engage the title company or will the attorney engage a title company?
So typically in this market, seller's attorney typically picks the title company. I'll tell you the reasons behind that in a moment. With that choice, my typical position representing our buyer clients is that unless it's a complete wild card title company that's chosen, we go with the seller's choice. The reason for that is your costs as a buyer are typically going to be less expensive if we obtain all title policies and close through the same title company. So if you have a loan involved at closing, there's actually 2 different title policies. There's an owner's title policy that covers your interest as an owner, that's paid for by the seller. There's a lender's title policy that covers the lender's interest. Now that is paid for by you. If we close through the same title company, the lender's policy typically is issued at a rate of about $550 plus about $180 per required endorsement. Whereas if you go to your own third-party company for that lender's policy, you're probably looking at a base rate to begin of about $1,900. So there's a significant cost savings. That's the main reason with it. You can go online right now and you're going to find some attorneys that are really heavily promoting how much they can get you a discount on your title fees. Be careful of anyone that offers you a significant discount. You might get the job done, but you oftentimes are going to, give up some quality on the actual work to get that discount. And if you're okay with that, I mean, that's not always the case, but if you're okay with that risk, that's certainly an option to pursue. Those people are out there. But yeah, typically this market, seller side chooses, and we go along with that unless it's, a third party company we've never heard of. But I mean, if the other side's working with like Fidelity or Chicago Title, those are kind of, some examples of great title companies in this market that you see every day.
Mm-hmm. Someone else wants to know if attorneys are involved in every home sale.
No, they aren't, but they should be. I mean, a few times a year on the seller side, we will have on the buyer side, we'll come across a seller that just refuses to work with an attorney. On the buyer side, it rarely happens, but occasionally it does as well. It's a horrible idea. I can't think of a single transaction that I'm aware of where both the buyer and the seller were unrepresented and got the deal done, which means you're going to have an attorney on the other side. So if you feel like taking out your mental samurai sword and trying to figure out all of this, back and forth and how the transaction operates, what needs to take place when, and do it with another attorney that's probably doing, hundreds of these deals a year. I mean, if you think you can measure up to that, that's great. I think for the majority of us, the better option would be, paying an attorney to look this over and be on your side. Keep in mind, when you hire the attorney, we're your fiduciary. We have an utmost duty of loyalty to you as the client. So that means if we see something that based on experience does not sit right, if you come to me, I'm going to tell you to get out of the deal. Some agents will do that, other agents won't. But my job is to protect you, whether you're the buyer or the seller. That's what you're hiring. You're hiring that fiduciary, and that's a huge benefit to you going through a transaction.
Great. So someone else would like to know what can happen during a final walkthrough.
Okay, well, think about the weather the last 72 hours. All sorts of things. I mean, you might get to, a lot of the time, final walkthrough goes well. But it's not uncommon to have issues that pop up, especially the last few years with this inclement weather we've been having, which just seems to be progressively more dramatic. Especially after like these giant rainstorms, these giant snowstorms, you might get in there and find out, oh, there's a brand new major leak. It might be a minor leak. I'd say those are the most surprising things that happen, and they tend to pop up after weather very similar to the last 72 hours. I'll give you one example, not on final walkthrough, but I have a client selling a condominium. I spoke with her just before this meeting, and we received an inspection letter. And during inspection, which took place on Saturday, so we were kind of in the middle of all of this weather, inclement weather that we've been having. Lo and behold, her second bedroom, the windows, we started seeing water infiltration. And I confirmed with her it's happening, but it hadn't happened before. It just popped up. So that's kind of an example of what can happen. That's also why I say in that slide, the closer proximity to the actual closing you can do the final walkthrough, the better off you are. Because, take, for example, we had all of the rain yesterday. If you did a walkthrough 72 hours out and you think you're satisfied, and then you go to closing 2 days later, you have that entire gap period that something could have happened with water infiltration. And after closing, If the seller's out of the property, they haven't inspected it, they're not aware, you're probably going to be out of luck. It's your problem. So the nearer to closing that you can actually do the final walkthrough, the better.
Okay, great. Thanks very much. Being the seller, is a deal execution different for a 50-50 cash and mortgage deal versus a 100% mortgage deal?
I mean, it's not necessarily. I mean, 50 cash mortgage, that's really just, essentially like a mortgage for a loan for 50% of the purchase price. So, I mean, from my perspective on the attorney side, no, it doesn't really change how things operate. Assuming your buyer is pre-approved for that 50% mortgage, I mean, I would think you're dealing with a pretty strong buyer, because they're going to, the lender's already verified that the buyer can bring that other 50% in cash. As an attorney, I might say I want to verify that there are the liquid funds available to cover that 50%, but no, it really shouldn't change things procedurally all that much.
If this is someone's first time buying a property, when would they hire the attorney? Do they tell the realtor or real estate agent? And what's the timeline for that?
Usual timeline that we see is that folks get us involved after the contract's executed. So we've just started that attorney review period, and we meet a lot of clients through our agent network of people that we know. When's the right time to hire an attorney? I don't think that there's ever a too early point on either the buyer or the seller side. For buyers that want to sign up and start working with us ahead of time, one benefit is if you're looking at a property and you have questions about that tax proration before going under contract, I'm always happy to take a look and say, okay, here's what the assessed value is at, here's how that compares to prior years. You can get a little bit more information about what you're doing before entering into the contract. Seller side, we are happy to provide, they're called net sheets. So that's going to take a number of variables like an anticipated purchase price, an estimated closing date, how much you might owe on the loan, put all of those items together. And, we provide you with a very specific breakdown of an estimate of how much cash you're going to take out of the deal. So if we're involved ahead of time, that can give you a nice idea before you accept the offer, exactly how much in proceeds you'll receive. Now, again, some agents do this, others do not. The good agents, we know they're all doing that as well. But sometimes even for our sellers, we can dial that in a bit more on items like the tax credit proration. So again, we can look at the public records and provide a bit more detailed explanation as to what we think will happen. So I'd say that, you can have us come in standard after you've accepted a contract. That's perfectly fine. But, on my side, I have no issue getting involved earlier, and to some extent prefer that as well.
Okay. Someone would like to know, if you're selling an older home, for example, your parents' house that needs a lot of work, should you do that as is, or should you do some small cosmetic fixes before putting it on the market so that there isn't such a big list upon inspection? Do you assume the buyers are going to be redoing, updating everything anyway and just go the as-is route, or would you try and address some of the issues?
That right there is a perfect example of where the real estate agent value comes in. So that's not something we really advise on as an attorney. I think the extent of my advice there would be, if you know there's a lot of work to be done and you don't want to spend a lot of time negotiating, that's where you go with as is. Okay. If you want to take less of a hardline stance, you probably you want to not go as is, you want to go with the standard inspection contingency. But keep in mind, the answer to that question, whether it's which repairs, which upgrades should we make to better the property value, that's the real estate agent that has that expertise. They're the ones doing the market comparables. They're the ones that are going to know, okay, if you do this improvement, it probably raises, the price, the value of the home by X amount. If you do this improvement, it sounds good, but it's not going to be actually affecting the purchase price. That's the agent coming in on it. So yeah, I mean, my expertise, it goes to the contract clauses and how that will play out. It's not if you make one change to a variable on the property, how will it affect the value and which ones are best?
Okay. Another question, am I at a disadvantage if I did not put my property into a revocable living trust prior to buying? What are my options at this point, and what are the costs associated with it?
Prior to buying, so just for a clarifying question, it's in your individual name hypothetically right now, and you would be looking to put it into a irrevocable trust, correct?
That's what I'm assuming. We'll wait to see if
Let's go with that.
we got a clip. Yes, we have a
I
yes
don't-
in the clarification. Yeah.
I mean, it's not necessarily a disadvantage. If you all, from the tone of the question, it sounds as though you already have a revocable living trust in place. First of all, not all lenders will let you close into the living trust. Some lenders will say, okay, buyer, you're going to close in your individual name, and then you can go ahead and put the property, title it into the living trust after closing. That's not uncommon. The two main disadvantages right now, if it's in your individual name, and let's just play that you have a revocable trust, you have a pour over will. I'm making a lot of assumptions here, so this is not legal.
They say that there is no trust in place yet.
Okay, well then you're not really at a disadvantage because you can't put it into the trust. And then again, it may depend on if the lender would actually let you put it into the trust for the closing. I mean, after closing, how do you get the property into the trust? The typical way of that is going to be the estate planning attorney you work with setting up the revocable living trust. It's going to use a quick claim deed to transfer from your individual name into the actual revocable living trust. Now, the fees on that's going to vary, okay? I don't want to say, here's what you should expect to pay for that, because are you putting in place the revocable living trust plan? How complex is your planning? You know, some attorneys will go a very low fee on that. Some attorneys that are going to want to learn more, and this is me, about your actual setup, what you have going on in life, what are your goals. We take a very holistic approach to estate planning. You know, we want to actually be your partner in that process, and that means getting to know you and your situation a bit better. Some attorneys, they're happy to do more of the form providing, and that's going to cost you less. So think like LegalZoom, but with an attorney driving. So, you know, if you shoot me an email and want to talk about that further, I'm happy to connect, but pricing is a bit of a difficult one to pinpoint just from that high level fact set.
Sure. All right, we have a very specific question that I have been saving for you. So we'll see how far we can get with this. So the question is, I am one of two owners in my 3-flat building. I didn't realize the president of the HOA hasn't been paying the water bill for at least 3 years prior to this person joining. He is now in foreclosure. I am also the only representative attending hearings, postponing the hearing until his condos are sold. He said when the bank sells the condos, they will also pay any debt, which is about $16,000 right now. Is that true? And what is the best thing to do moving forward? Can I separate my water bill so I'm not reliant on another owner to pay the joint bill? This is all typed in the Q&A if you want to have that in front of you to address any of it.
Yeah, that's very specific.
Yeah.
That's a bad situation. You need to contact a condominium attorney that likely has some experience in litigation for that. We don't litigate, and you're headed into a dispute process. But I mean, just high level, if the president owner of the association hasn't been paying water bills, usually there's documentation that was provided to lenders at closing stating that those water bills were paid or that the accounts are up to date. I question how that was happening. There's, you know, fiduciary duty as a member of the board to the association. Yeah, that's a mess. You know, I'm happy to try and put you in touch with a more of a condominium dispute resolution litigation attorney, but that's one that I can't just, you know, come up with an answer for on the fly here.
That's a tough one. We always like to throw one of those at you just to see what happens. All right. Does anyone else have any questions at this point in time? You could either put them in the Q&A section or in the chat, either way. So I'll give a couple minutes here in case someone is frantically typing. Do you have any closing thoughts that you would like to share based on any of the questions you've heard tonight, or just the overall market situation right now while we're waiting to see if there's any others?
Yeah, and this was one I kind of toyed with the idea of putting onto the slides because I think there's a lot of conversation right now focusing heavily on interest rates. So just kind of a little bit of perspective. If you're on the fence about whether you should be looking to buy right now, and it's that interest rate hesitancy. So number one, yes, the rising interest rates mean that affordability is going to go down a bit. But just to provide some perspective, there are advantages if you are willing to kind of scale back maybe what you're able to afford based on current interest rates. There's advantages to looking right now. You know, the past 2 years, you can go on Instagram, you can go on social media, follow these real estate agent accounts. The stories they're telling about, you know, people bidding $40, $50, $60,000 over asking to get under contract, waiving inspection contingencies. We were seeing post-closing possession for sellers where the seller remains on the property after closing when you own it. I saw one where my clients, against my advice, wanted to, they agreed they give the seller 60 days after closing, and there was no what we call per diem. That's where the seller pays like basically your mortgage, what you owe, so you're not coming out of pocket. They were basically, they were paying the seller to live in the property 2 months after. That's how bad they wanted the property. And I get it, but you don't have that right now. You actually have some bargaining power with the sellers. You're not having to bid $40,000, $50,000 over asking. Yes, you may have to scale back your search a bit as far as what you can afford, but there's some very real benefits to that right now. The deals we're seeing go under contract and close are structured much more normal. Say what we were accustomed to seeing pre-pandemic than what began happening probably about May of 2020 and onward.
Someone wants to know if they can request a move out date that will happen post closing, or is closing usually the hard deadline for move out?
It's usually you move out at before final walkthrough. Usually all of the possessions, personal property needs to be moved out. But yeah, as I was saying in that comment, it's what we call post closing possession. And that's absolutely something that can be negotiated. You really want to negotiate that before you go under contract. So that needs to be part of the purchase and sale agreement. So like one of the two forms, there's a long list of optional provisions, and negotiation of post-closing possession of a seller. I believe it's paragraph 36. And that's going to spell out how long you can remain in the property, how much. Usually we do an escrow, so you hold back a certain number of dollars depending on the time you'll be in the property. That way, if any damage happens on the way out, there's some money held back that the buyer has access to negotiate those repairs. And then also, what's the per diem? How much are you paying the buyer to stay in the property per day after closing? But it's best to have all of that negotiated at least in principle and put into the contract before you go under contract. That's a really big change to try and spring on somebody once you're under contract. Then have your attorney sort the more specific details out in attorney review.
Okay. With respect to interest rates, et cetera, are there any advantages to buying in this market?
I mean, the interest rate side of it, talk with the lender. But the advantages to me on the legal side are exactly what I just said. You're going to have a better time negotiating with the seller. You have more bargaining power than you did with the low interest rates. It means there's less buyers out there. You know, people became accustomed to having really great buying power when the rates were sub 3%. They lost quite a bit of that. So if you're willing to accept that you can't afford quite as much home, but you're going to be able to negotiate a better deal, if you can live with that, that's the advantage to me.
Okay. Someone else wants to know concerning selling an older home built prior to 1978. What's your recommended approach to handle the potential for lead paint?
I mean, if you don't have any reports on it, the standard answer is going to be you don't have any reports. I would anticipate that's going to come up depending on the buyer, but I would also argue single family home pre-72. I mean, if that's what the buyer's in the market for, talk with the agent, price it accordingly, but I don't think that that should be any reason that you necessarily have to anticipate coming out of pocket for major concessions unless there's some, you know, I'm trying to think maybe there's a large amount of paint flaking so that lead could be getting into the atmosphere. But you know, a number of those homes, maybe there's hypothetically a layer of lead paint behind newer paint. In my mind, that's kind of part of the bargain. You want the older home, you want that vintage. That's a risk. So I don't know if I'm a seller. I question how much I'd be willing to do, assuming I priced it correctly via the agent in the first place. I don't know how much I'd be willing to do on a buyer concession there, an inspection.
Okay. Someone wants back to the revocable trust question. To put the property into a revocable trust, this person would now have to negotiate with the lender.
No, estate planning is a carve out. So the lender is not, all of the mortgages have a due on sale clause. There's actually a carve out in federal law. If you're putting the property from your individual name into your revocable trust, and then also assuming that you're the primary trustee, like that's your trust, you're using it for estate planning purposes, you can do that without negotiating with the lender.
Okay. Someone wants to know, do we really need to go through all the legal documents line by line when purchasing a property because it's a bit overwhelming?
Short answer, you should. That's the one the attorney always gives you, right? But I know you don't. I mean, I'm an attorney. Like if I go sign up for software online, I don't always, you know, on the consumer side, I might not read through it. So I know the reality. What I would say is there's certain provisions of the contract that like they're going to be more important than others for you. Like what's the purchase price? What's your loan amount going to be? What's the closing date? I've had an inordinate amount of clients the past 2 years that didn't realize that the closing date in the contract is not a suggested time period. It's an actual day. Those are the main items. I'd say they're the main main terms of the deal. You know, like in commercial leasing, they would be the items we put on a letter of intent. Like those are the most important. And those are things that you as a non-attorney, you shouldn't need an attorney to explain them to you, right? You should have a pretty good idea of what they mean. The rest of it, the legalese, and then also if you have questions about those main terms, that's why you hire us. Again, you have the fiduciary. Our job is to go through that. The two main contracts that are in use in this market, I know them backwards and forwards. I can look in that contract in under 5 minutes, point out where all of the pitfalls are for your transaction typically. So that's the value you're getting with the attorney, another part of it.
And someone wants to know, what type of attorney should I engage if I'm trying to pair trust planning and a prenuptial agreement?
So if you're pairing prenup and estate planning and you want the attorney to do both, you are going to want an attorney that has that family law background. So I'll give you an example. Like I can help out with the purchase and sale of residential property. I can help out with the estate planning, but I'm not a prenup attorney. So just play the hypothetical. If I was working with you on a home purchase and we had some estate planning going and we wanted to make sure there's a prenup, I would refer you to a family law attorney with the expertise in that area. If you're doing all three and you can find an attorney that has experience and is good at all three and feels comfortable, that's the attorney you want. I feel like a lot of times it's like real estate and estate planning, or estate planning and family law, and not necessarily all three meet.
Mm-hmm. And our friends at the Chicago Bar Association do have a lawyer referral service that you can call or contact, and they will help match you with an attorney. If there is someone out there who has those joint specialties, they can probably help you locate them.
They might have that person that has all three.
They might, the unicorn lawyer.
Yeah. And I shouldn't say it's uncommon.
Right.
You know, you might also, for that, depending on your budget, that might be a spot where, say, a mid-sized firm where they have all of those practice areas, and then there's another attorney down the hall that has that prenup expertise. So an attorney in that type of firm setting might be ideal as well.
Mhm. Okay. And then someone wants to know if you could repeat your prices again.
Yeah, so keep in mind, this is the base rate where we start at. So on the residential transactions, for the buyer's side, flat fee of $795. For the seller side, excuse me, flat fee of $695. Most of the time, that's going to cover the transaction from start to finish. I say the starting rate because if you have a complex transaction, we are going to have to take that into account. So as I was saying, like the for sale by owner, that's more work on our part. Vast majority of the time, that base rate is going to be what our clients pay. And that's put on the closing statement. It's paid out at closing, so it goes into your closing costs, whether you're on the seller's side or the buyer's side. And we don't charge anything up front. So if you're working with us, you get a short engagement letter. We try to keep it pretty short and free of legalese to the extent possible. You sign that, we get to work. So we try to keep it pretty simple.
Okay, great. Well, thank you so much. We have a couple other questions that popped up. Someone wants to know if they're currently building a house, should they put that into a trust right away, or does it not matter, and can you do it later?
When you say currently building, are you buying a house that's being currently built, or are you the developer? And then you're going to sell it.
Let's see if there's a response on that. Let's see. They own, use in construction. It says own, use in construction. So it's for their own use. They're constructing
that one I need to know more about it. And I mean, if you already own the land, you might consider putting the land into the trust. When you're putting real estate into a trust, it's not about the improvements on the land, it's the actual land. So that's dictated by a legal description. So if you already own the land, yeah, you might be able to put that into a revocable trust now as opposed to later, depending on the specifics.
Great. And someone else wants to know, why should we not make any big purchases or have a large sum of money come in before the closing date?
Okay, well, talk to the lender for the exact specifics, but here's the deal. Don't go buy the giant $10,000 sectional couch or the yacht before the closing, because first of all, it impacts your credit availability. So if you make those big purchases, you know, your debt ratio is going to go up. There's no way around it. And if it goes up enough, it might impact whether you actually qualify for the loan. So that's the big purchases part. The cash infusion, the lender wants to know where the money's coming from. So if you have $50,000 drop in your bank account 2 days before closing and you plan on using it, yeah, it's not going to work. The lenders are going to have seasoning requirements. So that's how long money needs to sit in your account before you can actually use it. They may have gift letter requirements where the person sending you that money has to provide a gift letter. The underwriting on it is going to vary, but that can cause huge issues. The bottom line is, if you think there's a large purchase you're making, if you know there's going to be a large cash infusion, tell your lender or loan originator about that situation as soon as you know, and talk through it with them so that you can strategize how to make sure your deal doesn't go off rails. Because if not structured correctly, that can be a deal killer. And then, yeah, just talk with the lender.
Well, thank you so much for answering all these questions here tonight. It's very helpful. And for all of our attendees, you will be getting an email within the next couple of days as soon as we get this video uploaded to YouTube. And we'll also send a copy of the slides with Mr. Strain's contact information on it and all the other great information at the same time.
All right. Thanks, everyone. Have a good evening. Feel free to reach out to me with questions, or if you have any interest in discussing specific projects, always happy to be a resource.
Great. Well, thank you so much for your time tonight.
Thank you, Lorena.
All right. Have a good evening, everybody.